America has the greatest system of justice in the world. It's based on the concept that it's in everyone's best interest for criminals to be punished and the innocent to be free. Our laws demand that we are sure, beyond a reasonable doubt, of someone's guilt before we can convict him, and that the jury is given all the evidence to make that determination. After all, if we get it wrong, not only is an innocent person punished, a criminal goes free. 25 years ago in Alabama, a young mother in a small town was killed. After an investigation and trial, a man named Billy Kuenzel was convicted of murder and sentenced to death. But does he belong on death row? In 1988, a jury decided that he did. Since then, a lot of evidence has surfaced that the jury never got to hear. If we brought them back today, would they make the same decision? Was Billy the right man, or is the killer still free? Let's weigh the evidence and see what you think. On the night of November 9th, 1987, a store clerk named Linda Jean Offord was found dead at Joe Bob's Crystal Palace convenience store, the victim of an apparent robbery gone wrong. Here's what the prosecution told the jury at Billy's trial. In November 1987, Billy was working at a textile plant. A co-worker named Harvey Venn was looking for a place to stay, so Billy took him in as a roommate. On November 9th, the two spent the afternoon driving around together. Later that evening, according to Harvey, Billy proposed robbing a convenience store for some easy money. Harvey said they waited outside for about an hour until everyone had left, and that around 11 o'clock, Billy went inside with his stepfather's 16-gauge shotgun to rob the store. Harvey said that after a few seconds he heard a shot. Then Billy ran out screaming, and they fled. Harvey Venn was the prosecution's star witness at the trial. He entered a plea bargain with the prosecutor, which means in exchange for a reduced sentence, he testified that Billy had killed Linda Offord. To corroborate Harvey's story, the prosecution presented testimony from a woman who had driven past the store that night. She said that from the road, for a split second, she saw both Harvey and Billy inside the store. There was no physical evidence linking Billy to the crime. For his part, Billy told the court he had nothing to do with the crime. In fact, he was at home asleep when it happened and had an alibi. He said that Harvey must be framing him in order to save himself from the death penalty. So, if there was no physical evidence linking Billy to the crime, no motive presented by the prosecution, and a clear alibi, how could Billy have been convicted? At trial, Billy's defense was undone by a critical problem. Billy's key witness was his stepfather, who testified that he had seen Billy at home asleep on his couch 30 minutes before the murder occurred, 25 miles from the crime scene, with no car. A clear alibi. Furthermore, his stepfather testified that although Billy had borrowed a 16-gauge shotgun from him, Billy had returned that shotgun several days before the murder. Harvey testified that he had a shotgun in his possession that night, but that it was a 12-gauge shotgun, and so it couldn't be the murder weapon. But the jury had to find that someone had the 16-gauge shotgun that murdered Ms. Offord. Since a witness placed both Harvey and Billy at the scene of the crime, and Harvey only had a 12-gauge shotgun, the prosecution argued that Billy's stepfather must be lying about Billy returning his gun. And if he was lying about that, then he must be lying about Billy's alibi. To the jurors at Billy's trial in 1988, that was enough to make him appear guilty. And after a day-and-a-half trial, the jury deliberated for a few hours and returned a guilty verdict against Billy for capital murder. He was sentenced to die. But here's the thing. There was a lot of evidence that the jury should have heard, but didn't. Unfortunately, Billy couldn't afford an attorney, and his state-appointed lawyer spent almost no time investigating his case. After the trial, Billy replaced that lawyer with other volunteer lawyers, and these new attorneys unearthed significant new evidence, including some that the prosecution had in its possession, but despite their obligation to do so, never made available. That evidence tells a very different story. To begin with, Billy's new attorneys discovered that Harvey's gun was not a 12-gauge after all, but a 16-gauge shotgun, the same type of weapon used to commit the murder. Had the jury known that Harvey possessed a shotgun that could have been the murder weapon, would they have thought differently about Harvey's role? Would they have thought differently about Billy's stepfather's alibi testimony? Remember, if Billy's stepfather now was telling the truth about Billy returning the shotgun before the murder, then Harvey could have committed the murder alone, and the stepfather's alibi testimony now could be believed. And that's not all. What about that prosecution witness who supposedly saw Harvey and Billy inside the convenience store as she drove by? Billy's new attorneys discovered that before the trial, she told a grand jury that she didn't and couldn't identify anyone inside the store. The trial jury never heard that either. Another thing the jury never heard was a statement from the 13-year-old girl Harvey was dating at the time. She told the police and the grand jury that she saw Harvey before he went to the store that night and that he was most definitely alone, not with Billy. The jury also didn't hear that when Harvey was first arrested, he made repeated statements to the police that he had been with not Billy, but an old school friend at the store that night. Harvey gave the police his friend's name, a detailed description of his friend, and this man's place of residence. But the police never even tried to find the man Harvey identified. If the jury had heard that, maybe they would have thought differently about the 4 witnesses who saw Harvey at the store with someone other than Billy. The jury also wasn't told that 2 days after the murder, a police officer interviewing Harvey observed that he had a black eye and bruises on his arm that corresponded with injuries on the victim's body. Yet the police officer's notes were not made available until 2010, 22 years after the trial. If they were presented at the trial, perhaps they would have explained why Harvey, and not Billy, had the victim's blood on his clothes. Yes, that's right. The only physical evidence in this case directly implicates Harvey. He had the victim's blood splattered on his pants. The victim's blood was found nowhere else, and Harvey couldn't provide any explanation for how it got there. Finally, the jury never heard about motive. They never heard that Harvey was in desperate need of cash to pay attorney's fees for an upcoming drug trial, the kind of cash one might find in a convenience store cash register. Billy has always maintained that he was at home sleeping when the murder occurred, and that if a jury could hear all the evidence, they would believe him. But the jurors in that courtroom never heard a lot of that evidence, even though it resided in police notebooks and evidence rooms, even though it had been heard behind closed doors in grand jury rooms, even though the prosecutor had seen it all. It never made its way into the hands of Billy's state-appointed lawyer or the ears of the trial jury. Since Billy was convicted in 1988, he has been confined to an 8-by-5-foot cell on death row. Harvey was released in 1998. After a subsequent drug arrest and trip to jail, Harvey's back out on the streets. Was justice served? Does Billy deserve to be executed? Does the evidence weigh against him beyond a reasonable doubt? Given all the evidence we have now, would a reasonable person believe that Billy committed this awful crime? Or does Billy deserve one chance, one fair chance, to finally have his case heard? For more information, see www.alabamainjustice.com.